Okay, here we go. It's time to dance. We have a great show about when you get injured on the job. So take lots of notes. Here we go. It's time to dance, Terry.
When life gets tough and it seems like your best ain't good enough. If you're in need of hope, you know where I'll be. I'll be right here. Right here, and when you need a friend, you can count on me. I'll be right here, waiting for you.
This is the place you can always turn to when you need a friend. The Lillian McDermott Show. To reach out to Lillian, visit her on the web at whenyouneedafriend.com. Now let's all learn together. Here's Lillian McDermott.
Hello, my listening friend. It's so nice we can meet each other on the air on this beautiful best day ever. And for those of you who are new to the Lillian McDermott radio show, the purpose of the show is to provide a safe place where you can go to when you need a friend. It is my commitment to provide alternative ways to heal, and it is my mission to make awareness, responsibility, and truth a part of our everyday life. And I hope you, my listening friend, will feel empowered to live the life of your dreams and embrace a new truth. Now, today we are going to be talking to attorney Terry Byrd, and he is a workers' compensation attorney. So if you have any questions, you can feel free to call at 407-373-5959. That's 407-373-5959, because if it's a third Saturday of the month, then we're going to be focusing on Lily's legal dream team. But on this day, because of games, we get to do it on another day of the month. But keep your ears peeled, because the third Saturday of the month, we get to embrace legal questions with my dream team. Now, I want to ask you if you've been injured on the job. Now, this is something that I really never really looked at, because the kind of work I do, what kind of injury? Paper cut, there's not that many things that I would ever think about. But for many of us, an injury on a job is an everyday occurrence. But what happens? I knew this guy that he worked in a granite shop, and at the age of 40, he needed both knees replaced. He needed so much. His back was hurting. It just was so painful to him. At what point does our body absorb the things that we do? And at what point does our employer need to provide that safety, so that we don't get injured? Well, today we get to talk about workers' compensation benefits with attorney Terry Byrd of the law firm Byrd Byrd Attorneys at Law. They're right in Jacksonville, right there waiting for you. He's got over 28 years experience of representing injured workers. He's going to teach us what we need to do so that we can assess our own rights and take the action that we need. And since it is our sole purpose in life to give and receive love and knowledge, I am grateful that Terry Byrd of Byrd Byrd Attorneys at Law is here to do just that. Welcome back, Terry.
Good morning, Lily.
I know this is your first time on this particular station, and I'm just really excited that we get to talk about some of the things that we don't know when it comes to work. So share a little bit about your background and why you chose this specialty as your field.
Well, Lily, when I got out of law school in my 20s, I went to work for an insurance defense firm, a rather large firm downtown Jacksonville, and represented insurance companies when their insureds might be sued as a result of accidents that may have been their fault. And I did that for about 10 years and was very successful in representing these insurance companies and such. But I decided about 18 years ago that I wanted to get away from representing big corporations and start helping individuals fight their way through the legal system. And I thought I could benefit them with my knowledge of what I knew in the background of insurance companies and adjusters.
Yes. And so once you knew that truth, it was time to take that leap.
Yes, and so the fact that I've had all this experience on the other side in representing insurance companies is a definite benefit to my clients over the years, so they help understand what's going on. And I know all the players, I know all the adjusters and doctors that might be in the system and such. So that's a benefit to my clients also.
Absolutely. And so with all these years of experience, I'm sure you have a lot of stories of times where people didn't even know that they had a right to legal compensation. So whether it's medical or therapies. So at what point does someone say, I wonder if I have a case here? Can they call you at any time?
They can, and it's of no cost to them to meet with me and discuss a possible injury on the job. That's the good thing about workers' comp is I provide my services free of cost without any payment towards me unless we get you a settlement in the end, then I get a small piece of that.
Very good. And that small fee comes from an account, not necessarily from the person who was injured, right?
Right. Well, there's two ways that lawyers get paid under workers' comp. Mm-hmm. One is you get a lump sum settlement, and we get a small piece of the lump sum settlement.
Okay, and we're going to talk about the next part when we return worldwide at whenyouneedafriend.com. If you have been injured on the job, this is the show for you. We're going to discover what we need to know today. We'll be right here waiting for you worldwide at whenyouneedafriend.com.
I'll be right here waiting for you.
And here we go.
Your friend, you can count on me. I'll be right here waiting for you.
You can text Lillian McDermott or leave her a voicemail at 407-373-5959. Once again, here's Lillian.
And welcome back to the Lillian McDermott Radio Show, where we always learn from one another. And today's teacher is Terry Byrd, attorney Terry Byrd of Byrd Byrd Attorneys at Law. And if you have a question for them, it doesn't cost you anything to call. That's 904-731-0990. Now, Terry, when you were talking at the beginning of the first segment, you had mentioned that somewhere along the way, something happened where you felt, I want to go to the other side. I need to represent the little people instead of the corporate world. What happened? What caused you to say that to yourself?
Well, you'd have to work for the insurance industry to understand that it's kind of a cold, corporate mentality. And I just didn't feel that I was, achieving the types of things I wanted to do in the law by helping insurance companies make bigger profits. So I wanted to help the little guy. And that's just more of my personality, that I wanted to, feel like I made a difference in people's lives when it came to the problems that occur, both in personal injury and also workers' comp.
So was there a case that happened? I mean, was there anything in particular that triggered that? Because in order for us to make a change, something happens in our life that says, because we know deep inside this is what we want, but until something dramatically happens in our life, sometimes we're not changing. Was it a case, someone that came to you? Anything happened in particular?
Yeah, I don't know if it was a specific case, but it was several cases where I felt like while I was able to save the insurance company a significant amount of money towards a particular case, I didn't feel, overjoyed for that because maybe the injured individual didn't get what they expected out of the case based on my efforts. So I felt I better switch gears and help people with their problems, and so that's why I switched.
Very good. And so I had shared an image that I had of this young man, 40 years old, walking like a crippled man. He worked in a granite yard, picking up heavy things. Now, is that the responsibility of the employer, or is it the responsibility of your responsibility for making sure that if it's something that you can't pick up, you don't pick up? But men and women sometimes want to do it ourselves. At what point do we decide, I have a case here, I need to do something different, I need some help?
Well, I would always encourage people in workers' comp to report an on-the-job injury immediately to your supervisor. In fact, you actually have 30 days to report your on-the-job injury under the statute, but I would report it immediately to your supervisor and let them know that whatever your injury was happened as a result of something that you were doing on the job. So it's clear to the supervisor that not one, that you got hurt, but also that it happened as a result of something you were doing on the job. There's so many instances where the employee says, I told my boss that my back was hurting. Well, then you get into the case a little bit and the boss says, well, yeah, he told me his back was sore, but I didn't know why his back was sore. He never said because he was lifting or bending, picking things up. He just said his back was sore. So I assumed that maybe he got hurt at home or he was doing something at home. So there's always these employers and insurance companies are always looking for a reason to deny your case and prevent from any benefits being afforded to you. You gotta really understand that, especially in workers' comp, they're constantly trying to find a way to deny your benefits. So you must make it very clear to your employer, one, that you got hurt, and two, it happened as a result of something that you were doing on the job. So they can't come back later and say, well, I don't know what you were talking about. You didn't even mention that what you were doing on the job. I thought it happened somewhere else. And so you don't want to give them any outs.
Okay, so how do you know something has been reported? Is there something that you need to sign? Because if I go to my employer and say, I picked up that motor and as a result my back hurts, and I mention it to my manager, but my manager forgets to write it down, how do I know I'm protected?
Well, you won't know because they're really required to report an on-the-job injury immediately to the insurance carrier. But a lot of times employers are reluctant to do that. And there's a very number of reasons. A lot of places, they want to be an injury-free workplace, and all of a sudden, you've been hurt terribly, but they don't want to report it because there's bonuses and stuff like that that go to everybody if there's an injury-free workplace. See, the whole motivation is to keep their premiums down. And in order to do so, they either try to deny your case or not report it to the insurance industry. What you want to do is report it and ask the employer to provide you medical attention. In other words, can you send me to a workers' comp doctor? They're required to do that. And if they don't do that, you need to come see an attorney to file a petition to make them do the right thing for you, because ultimately it's your body that you should be concerned with and not so much your job. A job's a job. You can have a number of jobs in your lifetime, but you can only got one body. And if you let that go to the wayside because you're afraid that maybe you're going to lose this job, then you may regret that decision down the road when in fact they deny your case and you're left with a tore up body and no job. Okay,
so I guess I want specifically, if I report that something happened to me, am I to ask to be sent to a doctor, or am I to ask for to write something up so that I can sign it? Are we supposed to sign a documentation saying that I got injured and as a result of this, I need to see a doctor? Maybe not today, but maybe 31 days down the road.
There's no requirement that you actually have to sign something to report it, but they are required to report. The employer is required to report the injury to the workers' comp carrier. And if they don't do so, you need to be proactive in the sense that you ask the employer to provide you medical assistance. So many times in depositions, I hear my clients being asked, well, so you say you reported an injury to your boss, and we know that your boss is saying, no, you didn't. Did you ever ask for medical treatment? And so many times they'll say, well, no, I just told them I was hurt and just assumed that they would provide me something. Well, it's important to not only report the incident to your boss, but also to ask for medical treatment or be sent to a primary care physician to be looked at. And if they don't do that within the first few days, you need to come see a lawyer, because they are on the process of trying to thwart your claim and not let you report it or not let you see a doctor, and ultimately try to deny your benefits that are due and owing under the system.
Okay, but if I come see an attorney, let's say I've asked for medical, I've reported an injury, I've asked to see a doctor, and they're like, saying, yeah, I'll take care of it. Now I come see you. At what point does my employer get upset that now I've stirred up the pot and now I've gotten an attorney involved? Would I be protected about losing my job?
Yes, there's a specific statute under workers' comp that prevents them from retaliation. If they were to turn around and retaliate against you for just asking that a workers' comp case be opened up and they provide medical treatment, then they can be sued under the workers' comp retaliatory discharge or statute.
And what does that mean, John? What does that look like?
Well, what it means is if, say, for instance, you report your workers' comp claim and they turn around and fire you because of that, well, then you've got an unbelievably good lawsuit against them for retaliatory discharge pursuant to the statute. There's a statute right on that, because employers are a little bit weary of doing that. They know about this statute. They don't want to get sued. They are to provide you these benefits, and if they don't do it, they need to hear from an attorney. We need to file a petition for benefits on your behalf.
Got it. Okay. So now so first we report, then we ask to be sent to a doctor. Have there been cases that you've represented that this has happened and they've come to you, and how have you handled it? What's the first step what is the first thing you do?
The first thing we do is file a petition for benefits, which hopefully is going to be within the first 30 days of your injury, but it doesn't necessarily have to be. It's all going to be evidence. So if it's within the 30 days of the injury, then we're good with regards to notice. They're not going to be able to deny the case because they didn't know about your injury or claim that they didn't know about your injury within 30 days. If it's after 30 days, then it's going to be an evidentiary hearing with regards to what did you say to the boss, and did you ask for medical treatment? And then they're going to have their folks from the employer saying, well, Joe never reported this to us. He never said anything. Or he did report it. He did report his back was hurting, but he never said it was a result of anything he was doing on the job. So we just assumed. And Lily, you got to understand, they don't want to know. So if you say, hey, boss, my back's hurting, they're not going to follow up with extra questions. Well, did that happen when you're lifting that 80-pound bag? They won't ask you that question because they don't want to know that you got hurt on the job. I hear
you. Okay, so as we go for this, what am I entitled to? So now I hurt my back or I hurt my toe, whatever it is, but I'm not feeling well. Now what happens? What am I entitled to other than go to see the doctor?
Yeah, the benefits are somewhat limited in Florida. Workers' comp is provided in all 50 states now, and every state is different with regards to the benefits that you're entitled to when you get hurt on the job. Florida's not very good with regards to the benefits, but you are entitled to medical treatment, and they pay 100% of your bill for the treatment that you're needed from the on-the-job injury. If the doctor has you off work, say he has you totally disabled from the injury, and he wants you off work completely on no work status, then you're going to receive 2/3 of your average weekly wage while you're off. And the way they calculate the average weekly wage is they take a 13-week wage statement, the 13 weeks leading up to your accident, and they average those pay periods, and that's your average weekly wage. And then they pay you 2/3 of that average weekly wage if the doctor has you on a no work status. If he has you on a light duty status, and the employer says, well, we got light duty, come on in, then you're required to go, sit there and answer a phone or whatever. So they'll pay, the employer will pay you during your light duty status. But
do they pay you, Terry, do they pay you that light duty job, or do they pay you your current salary?
It depends. Most employers will pay you your current salary while you're in there doing light duty. Some employers says, well, this is a more menial job and we're only going to pay X amount of dollars. But if it doesn't equal at least what we call TPD rate, then the workers' comp has to supplement.
And TPD rate is? What does TPD stand for?
Temporary partial disability.
Awesome. Okay. And we're going to continue learning these tips. For if you have any questions, you can call or text 407-373-5959. But you can always call 904-731-0990, which is the number for Terry Byrd of Byrd Byrd Attorneys at Law. And we're going to continue our conversation with Terry and learn more about workers' compensations when we return worldwide at whenyouneedafriend.com. We'll be right here waiting for you.
I'll be right here waiting for you. When you need a friend, you can count on me. I'll be right here waiting for you.
You can text Lillian McDermott or leave her a voicemail at 407-373-5959. Once again, here's Lillian.
And welcome back to the Lillian McDermott Radio Show, where you can hear us worldwide at whenyouneedafriend.com. I am your host, Lillian McDermott, and it is my goal that we learn from each other. And I'm so excited to bring Lily's Legal Dream Team. How many times have you wanted to sit with an attorney but didn't have maybe you think it costs too much money to sit with this particular attorney, so there may be some questions that you've had in the back of your mind about your job? Today is the day, because we are talking to Terry Byrd of Byrd Byrd Attorneys at Law, and the topic is workers' compensation. I want to encourage you to go to lawbyrd.com, and that's LAWBYRD.com, and their number is 904-731-0990. If you're driving around and you're going, oh my gosh, I got injured on the job and I don't think I said anything to anybody because I am afraid to lose my job. And something like that, Terry, how would you help somebody get to that next level to say, well, these are the payoffs, these are the prices. So help me understand, if I'm afraid I could lose my job because I got injured, what would you advise me to do?
Well, a lot of people are afraid to lose their jobs in workers' comp, and it is a shame that the employers look a lot of employers, not all of them, look disparagingly on people that get hurt on the job. But ultimately, like we discussed earlier, it's your body that you better be concerned about, because this job may come and go, but your body is the only one you have. And if you end up with a bad back or a bad leg or whatever, and you end up, say, not being able to be a truck driver anymore, but you should have reported that injury way back when, then you may forever regret that decision. So I encourage people that there's protections under the statute that prevent employers from retaliating against you in any shape or form for asking for the benefits that you're entitled to. That's the reason they bought the workers' comp insurance is for the very reason that you were hurt on the job. So to deny or to prevent yourself from doing so can be a big regret for you if it turns out later that you don't have that job anymore, but your body's still messed up.
Well, if you are, and that makes sense. You know, your first is your body. Jobs come and go, just like relationships, you know, and as a life coach, people go, but I love him or I love her. Yeah, but they weren't the right one for you. Because if they would be the right one, we wouldn't be talking right now, would we? So here we go with this. Are there particular industries that are more susceptible to filing workers' compensation, or that need to file?
Well, yeah, obviously the construction industry is the one industry that's actually required to carry workers' compensation on their employees, especially roofing.
Mm-hmm.
And they, you know, as a result, they have the highest premiums also. So you see a lot of roofing companies that have a lot of workers that aren't even on their payrolls because they don't want to pay the workers' comp benefits for these individuals. And it's very sad sometimes because, you know, obviously those are the worst injuries, falling off a roof. You can get hurt very badly. And so many times I see roofing companies that have employees that they have no coverage for because they didn't want to pay the premiums for them. And so there's some avenues we can go after them in civil litigation if they didn't have the required workers' compensation. In Florida, if an employer has 4 or more employees, they're required to carry workers' compensation for their employees. If they don't, they can be subject to negligence or liability under the civil litigation. So, you know, I guess we can harken back to why does workers' comp exist? Yeah. About 100 years ago, employees would get hurt on the job and there was no workers' compensation or anything of that nature. So when they were out of work, losing wages, or they're incurring medical expenses, there was no way to pay it unless they had some type of health insurance. Well, so what they ended up doing was suing their employer for negligence to try to get compensated for what happened on the job. Now, not all accidents on the job are as a result of somebody's negligence, but the ones that were costing the employers a great deal of money. They were bankrupting a lot of employers due to these negligent lawsuits. So they all gathered together, employers, and they lobbied the legislature, and they come up with this statutory scheme called workers' compensation.
Scheme, I love the word.
So, but what it says basically in workers' comp is that employers will provide certain benefits, i.e. medical treatment and also a portion of your wages while you're out of work due to on-the-job injuries. And the only thing you have to prove is that you were hurt on the job. You don't have to prove it's the result of somebody's negligence that you got hurt. You just have to prove that you were hurt on the job doing something that was job related. And in exchange for those benefits that the employers are giving you for wages and medical treatment, they get immunity from negligence. And that can really hurt sometimes when I had a case one time where a gentleman lost his hand in a machine, and it was due to the clear negligence of the employer, just terrible negligence on their behalf. But because they had workers' comp, he was not able to sue that employer for their negligence and get all the damages that he would normally be entitled to, like you are in auto accident cases, you know, pain and suffering and mental anguish and loss of earning capacity, all those intangible damages that you get in those types of cases. All he was relegated to was some medical treatment, which there wasn't a whole lot of medical treatment because he basically lost his hand and there was nothing more they could do. And he got some wages while he was being treated. Once the doctor concluded his treatment, then he's no longer entitled to his wages. So it was a horrible, horrible injury that he was unable to pursue his negligence theory because of workers' comp. You know, now there's a flip side to that. There's cases I've had where people were terribly hurt, but it was due to pretty much their own negligence. And they were able to receive a tremendous amount of medical treatment and wages into the future for an accident that was probably their fault only.
That doesn't sound like it's fair. And I know I say that, life isn't always fair, whatever we make from life. But here's the situation where this gentleman loses their hand. Did that employer keep him on? I mean, what happens when you lose a hand? Where do you go work after that?
Well, in that particular case, he was unable to achieve what they call permanent and total disability benefits because, remarkably, there are a number of jobs that you can work with one hand. It doesn't make you totally disabled because you lost a hand. And the employer only has to show that you can work any job, not the job that you were hired to do to prevent you from getting permanent and total disability benefits. So if they can show that you can be a greeter at Walmart, then they will be able to thwart your claim for permanent and total disability.
What about loss of income? Let's say I'm making 6 figures. All of a sudden, I don't have a hand or an arm, and I need to be the greeter at Walmart making, I don't know how much they make. Can I prove that the loss of income is going to change the way I live?
Well, it's certainly a damage, but it's not recoverable under workers' comp. It was back in the 90s. They had what they called loss of earning capacity, which clearly in this scenario that guy had.
We need a time machine, Terry.
So if it had happened in the 90s, he would have been entitled to what they call loss of earning capacity, which, these employers, they lobbied the legislature back in the 90s because they didn't like the cost that they were paying for these loss of earning capacity claims. And lo and behold, the legislature took that out of the statute, and there's no longer entitled to the employees getting that benefit.
Wow. Okay, so earlier you talked about 13-week average to come up with the 2/3 of your wage. What about if someone is on commission and they had their best 13 weeks ever? Do they take those numbers too?
Yeah, so it's a double-edged sword. If your 13 weeks leading up to the accident were really good weeks, then your average weekly wage is going to be very good.
Yes.
But the flip side happens more often.
Yeah.
It happens during a lull, or you were sick during that period of time, or there was different things that were happening that lowers your average weekly wage, which you end up getting much less pay under workers' comp while you're out, unfortunately.
Oh, boy.
Now, when lawyers get involved, we ultimately want to not only secure the benefits that you're entitled to under the system, but also we want to get you a lump sum settlement, hopefully at the end of the case, which will hopefully be good for you.
I would like to talk about that lump sum and what does it mean to get a lump sum, and where do you get paid as well? Because that's always good. You always think that you can handle it yourself, but an attorney can do a better job. I'd love for you to give us some examples of someone working a case without an attorney and someone working a case with an attorney. And we're going to continue our conversation with Terry Byrd of Byrd Byrd Attorneys at Law right here in Jacksonville. And we're going to continue our conversation when we return worldwide at whenyouneedafriend.com. We'll be right here waiting for you.
Right here waiting for you.
Man, Terry, it's going too fast.
You can count on me. I'll be right here waiting for you.
You can text Lillian McDermott or leave her a voicemail at 407-373-5959. Once again, here's Lillian.
And welcome back to the McDermott Radio Show. We always learn from one another. And today's teacher is Terry Byrd of Byrd Byrd Attorneys at Law right here in Jacksonville. They're right here waiting for you to call them at 904-731-0990. That's 904-731-0990. Now, I want to encourage you to go to whenyouneedafriend.com, because I always talk to you about my sponsors. Well, guess what? Byrd and Byrd, their sponsors, the Lilly's Legal Dream Team, these are all attorneys that are like-minded and have joined forces with the Lillian McDermott radio show. They are partners of the show. You can check them out on my sponsorship page. And I want you to share with your friends. If you know of someone who needs a family law, a family lawyer, a personal injury lawyer, a criminal defense attorney, or workers' compensation. So I want you to keep them in mind as you go forward in your life, because these are the people that align with my philosophy, and I'm so excited to bring them as Lilly's Legal Dream Team. Now, before we went on the break, we were talking to Terry Byrd about what's going to happen. What happens at the end of the case? And we started talking about lump sum. What is this lump sum of what the what? So I'm thinking I'm just going to get my medical payment or my medical treatments paid. But what is the lump sum, and what is that for?
Well, first of all, my main focus when I'm handling a case for an individual who's been hurt on the job is to help secure the benefits for medical treatment and also wages while you're out of work, and work you through the system to where you can hopefully make a recovery from your injuries. But at the end of the case, a lot of times we are able to get a lump sum settlement from the insurance company. In workers' comp, there's no requirement that they settle with you. They don't have to pay you a lump sum, but typically when you have a lawyer, we can make it happen. So a lot of clients say, well, how do I, evaluate a lump sum? Well, that's why, my 28 years experience helps you determine whether or not you should settle or whether you should settle for this amount. But typically what you've got to remember is that the insurance companies it's a business decision for them to offer a lump sum, because there's no requirement that they pay you a sum of money, and there's no mechanism to go to a judge or a jury in workers' comp to get an award of money.
Sure.
So all they're required to do is pay a medical bill when you incur one and pay some wages until the doctor puts you at maximum medical improvement, and then they're off that. So, what they look at when they're determining whether or not to pay you a lump sum is what are you possibly going to cost them into the future for medical bills or wages. So it's always a good step to try to get your case in a settlement posture while you're still costing them some money with regards to medical bills or wages. If you wait till the very, very end and they close down the medical and the wages and there's nothing else into the future, they become very uninterested in a lump sum settlement. So you got to keep in mind that there's no payment in workers' comp for pain and suffering, mental anguish, loss of earning capacity, any of those intangible damages that you get in other types of personal injury cases. There's nothing to do with workers' comp. Medical bills and some wages is all they think about. And a lawyer can help you obtain that settlement, and it doesn't cost you to have your lawyer on the case unless he is successful in getting that lump sum settlement for you. And then the lawyer takes a small piece of that.
So the lump sum is where you get paid?
Yes. Mm-hmm.
Okay. So if you don't settle for a lump sum, how do you get paid?
There's two ways lawyers can get paid under workers' comp. One is through this lump sum. We get a contingent fee off of that lump sum. The other is if we file a petition and we obtain a benefit, say a doctor's orders an MRI, and for whatever reason the employer or the insurance company takes forever and doesn't authorize that MRI, and then later down the road we're able to get that MRI authorized, then the insurance company is penalized by having to pay an attorney fee for you seeking that benefit that they initially denied.
Interesting.
So that's the other way that the lawyers get paid.
Okay. And so, you and I have talked a lot about the fact that you needed to get out of the other side, the dark side. And when I get you, kind of like I see a spark in your eye that you're a man with a mission, with passion, because of the corruption that is in this industry. Would you like to share a little bit about, make us aware, what is the corruption that is going on?
Well, it's a built-in bias where the statutes have been written to favor the employer in the insurance industry. And I'll give you several examples. When you get hurt on the job, the insurance company gets to pick your doctor. You don't get to pick a doctor. You don't get to go to your family doctor or your orthopedic or whoever you particularly might like, even like you do under a health insurance policy.
Sure.
They pick the doctor. Well, so many times we see that they pick the same doctor or the same couple doctors. And the reason they're doing that is because that doctor is going to be super conservative and not provide what we believe is the treatment that you might necessarily need, or the extent of the treatment that you might need, or send you back to work when you might not really be in a position to go back to work. So it's infuriating to watch the medical industry do this to on-the-job injured workers. And in addition to they get to pick the doctor, they also get to have a nurse case manager go talk to your doctor about your condition and whether or not you can go back to work, and basically go back in the room with the doctor and talk specifically about your treatment and your injury. Whereas, under the health system, if you have
isn't that a violation of HIPAA?
Yeah, they waive it for workers' comp. So because that's how the statutes have been gerrymandered in favor of the insurance industry. So a nurse case manager will a lot of times communicate with the injured worker before they have a lawyer, and a lot of times be very nice to them. And the injured worker doesn't know a lot of times that nurse case manager really isn't, in your best interest. In other words, she's trying to keep you a lot of times from limiting your treatment. So to limit the exposure that the insurance company has for future payments of any medical treatment. And then when you get disenchanted with a particular doctor that they picked, you do get a one-time change into the system, a one-time change of doctor.
But you have to prove that why you're disenchanted?
No. You get an automatic one-time change of doctor, but before 2007, the statute used to read that you would get to pick, you finally would get to pick your own doctor as your one-time change. Well, they changed that statute too. So now if you ask for your one-time change because you're disenchanted with your doctor, they get to pick who your one-time change is, as long as they do it within 5 days of your request.
Terry, it seems like the more you dig and more we ask, the more we realize that we need someone like you to represent us. If somebody is listening to you right now and going, yeah, that lump sum will be good, but I don't want to be without a job. Fear, I'm afraid that I might get fired. I'm afraid what could happen. What would you say to someone like me that would be going through fear that I might lose my job?
Yeah, so often we see that somebody that gets hurt on the job, they pay workers' comp benefits too, and then by the time they get back to work, all of a sudden they feel like a pariah. In other words, the employers are acting different towards them and ultimately try to find a way to squeeze them out of the job anyway. So often we see that if you're hurt on a job, then now you become more of a liability to the company, and now you're going to end up losing your job anyway.
Yeah.
So you might as well protect yourself while you can.
Okay, well, here we go. Now you hear the story. Thank you so much, Terry, for sharing what we need to know. And I want to encourage you, my listening friend and my viewing friends, if you're in the Jacksonville area, call 904-731-0990 or go to the internet at lawbyrd.com. Thank you so much, Terry, and I look forward to our next conversation.
Thank you, Lily.
And to you, my listening friend, I'll be right here waiting for you. This is Lillian McDermott wishing you love, peace, joy, and unexpected abundance. Make it the best day ever. Wow. Thank you so much Terry, for that. I'm going to keep the cameras rolling. Are there, hold on.
Yeah.
Okay.
So
Let me ask the question. Do you have any statistics of how many people get injured on the job and how many people actually sue for their rights?
Well, we know that approximately 700 to 1,000 workers get injured in the North Florida area each month.
Just North Florida.
Just north. I'm just talking Jacksonville and the surrounding counties.
Wow.
Between 700 and 1,000 are reported to the Department of Insurance, because the employers are required to report on-the-job injuries to the Department of Insurance, and they keep the statistics. Now, the percentage of people that actually obtain an attorney is quite, it's probably more than 50% of injured workers end up getting a lawyer in the system, because it's such an unfair system to the employees that they become very disenchanted, as as we described in our discussion.
Like you said, you may not even sue and get an attorney. You might still get fired from your job. So you might as well get someone to walk with you, be by your side to help you navigate the system.
Yes. And there's only one employer right now in Florida that does not require that you resign your job when you settle your case. So the vast majority of them still want a release and resignation at the time you settle.
Wow, it's unfair. Are there any people working on the behalf of the quote unquote little people that deserve to have balance? If there's negligence, they shouldn't be protected. If you can prove negligence, like the guy that lost his arm or his hand, is there anybody fighting on the behalf of the employee?
Well, if your injury is due to the negligence of your employer only, then it's a huge hurdle to beat the immunity. The only time you can really beat the immunity is if you show that it was an intentional tort. In other words, they meant for you to get hurt somehow, and that's almost impossible to prove that somebody meant for you to get injured.
Yeah, but so here go. I'm going to put my life coach hat on, and I always say, based on your results, what was your intention? So if someone's being reported that this could cause a potential injury, and they do nothing about it, it may not be intentional, and they didn't want to hurt you, but the fact that they didn't do anything about it, wouldn't that say to me that if they would have fixed the problem, I wouldn't have gotten injured?
Yes, there is a very narrow avenue to, if you were able to show that an employer ignored numerous warnings that this is going to cause severe injury or death, then you might be able to get around the immunity statute. But it's very difficult, and you don't see it very often at all in Florida, especially. Now I handle a lot of cases where an employee gets injured on the job, but it's the result of a third party's negligence. For instance, say a particular machine hurts you and it's due to a product's liability. It's not your employer, but it's actually the machine that malfunctioned. Or, for instance, a lot of times employers will have vendors that show up at a particular job site, and that vendor somehow injures you. In other words, I've had cases where a FedEx truck backed into a thing and injured an individual that was working at the warehouse. So FedEx was responsible for their injuries so you had both a workers' comp case going, and I could sue under a negligence theory against an employer like FedEx.
Very good. Very good. So that's good to know too. So this reminds me of when my daughter was in a car accident. She was hit by an uninsured motorist, but the seatbelt didn't work well. So the personal injury attorney that was representing her, went after the seatbelt manufacturer.
Right. So there's different avenues to go.
Okay. And that's what's important about going to see you. And it doesn't cost a thing, right?
That's right. Us lawyers work on a contingency basis.
Okay. And so for those of you who would like to visit and you would like to contact, of course, we gave you the number, 904-731-0990. But if you want to go to their physical address, that's 1646 Emerson Street, Suite A, Jacksonville, Florida. Again, their number is 904-731-0990. And that is right in Jacksonville, and they are waiting for you. Thank you, Terry, for not only coming on the show today, but for believing on the show and helping the information that comes from the show be broadcast and said way out loud, way out loud. So thank you.
Thank you, Lily.
And we're to our next conversation. I look forward to speaking with you.
Okay.